We have a little bit of a mystery surrounding the First Amendment lawsuit filed by Matt Gaetz and Marjorie Taylor Greene. A little bit of background here. This is from the Daily Beast's Roger Sullenberger. Gaetz and Greene had filed a lawsuit in July against two California cities and a group of left-leaning nonprofit organizations over a canceled political event during their ill-fated joint fundraising tour back in 2021. Y'all remember that? I do. I remember making fun of it because they ended up losing a ton of money. They spent more money than they raised. Awesome. Now, the plaintiffs included Gaetz and Greene in their official congressional capacities, along with their campaign committees and their joint fundraising group, Put America First, which put on the 2021 tour. The parties filed the suit on behalf of themselves and the prospective attendees at the July 17, 2021 scheduled political rally. Now, again, this was supposed to happen in two cities in California. Can't imagine they would have raised too much money from that, but they sued, saying that we were denied our First Amendment rights. There was a conspiracy. Now, these cities were Riverside and Anaheim, and they claimed that these liberal groups, including the NAACP, were conspiring with the cities in order to deny them their freedom of speech. Yes, or freedom of assembly, to be able to hold this political rallies. Now, there's no evidence of a conspiracy theory. In fact, last week, U.S. District Judge Hernan Vera wrote that their lawsuit was, quote unquote, utterly devoid of any specifics plausibly alleging such an agreement between these groups and the two cities, and added that it was both legally and literally a conspiracy theory that relies purely on conjecture. Yes. Now, what happened is, look, whenever you have insurrectionists, which that's Gaetz and Greene, wanting to come to a city, there's going to be pressure from groups, liberal groups, left-wing groups, to say, don't allow them to speak here. Now, you could agree, you could disagree with that, right? And look, if you disagree with that, you may have a good point because you don't want to suppress their speech, right? Have them come and listen to what they say. Now, and then again, if you're on the other side, you could argue we don't want to give a platform to insurrectionists. It's actually a really interesting conversation that you can have on this issue. But what Gaetz and Greene tried to do is, in their, fighting for their so-called free speech, right? And their freedom to hold these rallies, these political rallies, which are essentially fundraisers, they actually have tried to deny these liberal groups their freedom of speech. And so it's bizarre, okay? So city officials, they got pressure from these groups and were like, oh yeah, maybe it's a good point. Maybe we shouldn't host these insurrectionists and terrible people. And again, you could be mad about that. You can agree, as the judge does, that there could be an issue with viewpoint discrimination on the part of the city. But Vera added that Greene and Gaetz' attempt to punish the civic groups for speaking out and mobilizing their members to, speak out against these rallies is kind of the same thing that they're accusing these groups of doing. And so he wrote, all that is left to aver against the nonprofit defendants are the unremarkable allegations that they exercise their own First Amendment rights to lobby for the cancellation of the event. That is protected. So now, while this case is ongoing, their attempt to use the Ku Klux Klan Act against the groups, which again included the NAACP, was roundly rejected by this judge. Yes, that is what Gaetz and Greene's legal team, which includes John Eastman, argued. Vera wrote, the effect of plaintiffs' unprecedented and stunningly deficient pleading, hauling 9 civil rights groups into federal court for speaking out against an event, should shock in equal measure civic members from across the political spectrum. Yeah, they have their right to have their free speech and to say, hey, we don't want you having, people like that come and speak in our cities. We're going to give you pressure to cancel the event. That's different than a conspiracy. That's them using their free speech to lobby which we all have. Now, funny enough, before I get to this, again, the context, right? Because I'm giving you the background, I'm giving you the context before we even get into the mystery, okay? But as a side note to this, John Eastman can no longer practice law in California. He was disbarred. Oops. So, now that said, he's representing Gaetz-Greene, but wasn't the head of the legal team, but was still a part of the legal team. Now that's where we get into the mystery, right? Who's paying the legal team? Where are they getting the money? Who's funding the whole thing? That's what's going on here, because it's not Gaetz-Greene. In fact, it's not even anyone affiliated with Gaetz-Greene. In fact, over the last year, according to the report, there are no federal campaign finance records of any payments or debts owed to any of the lawyers on the case from any of the political committees associated with Gaetz-Greene, or any federal political committee at all. What? Hold on. No record of any money changing hands. And look, they've done this for several years, okay? They've worked on this lawsuit. It's not like they haven't done anything. There's been motions. There's been different things that are introduced. They've done a lot of legal work over these past few years to get this, case presented and to win this case. They're actively attempting to work and to win this case, as they should. But then who's paying them? Got to eat. You can't just work on a case for a couple of years and not get anything for it. So, but there's no records of it. There's no records of any of the money. Not only that, but Gaetz-Greene haven't even advertised the lawsuit to their supporters, which you'd think that they would be like, help us fight for freedom and free speech against communist California cities canceling Trump supporters. Yeah, something like that. You just throw in as many of those dog whistles or buzzwords that you can, and Trump supporters be like, oh, yes, take my money, please, take it all. But they haven't done that. No calls for fundraising on this. That's even weirder. Even weirder. Campaign finance professionals have said they would need to disclose this information under the law, the financial stuff. Generally, any vendor needs to be disclosed, said Citizens for Responsibility and Ethics in Washington Communications Chief Jordan Leibowitz. Campaigns can take on a debt to a law firm and then pay it off over time. That's not unheard of, to pay in one fell swoop after a campaign, but the debt to the firm would have to be reported for the services. But there's no reported debt. There's no record of the cost of any legal services related to this case at all. What? So there's literally no receipts, no paper trail, nothing. No payments at all. So you think, okay, well, maybe they were volunteering their service. That's a possibility, right? Campaigns and committees can accept volunteer legal services. That said, it's pretty limited to FEC-related issues. This is not an FEC-related issue. This is a First Amendment lawsuit. The value of those volunteer services have to be reported, but there's no report on that, so it can't be this issue, okay? So that's not it. Okay, but what if they're being, represented pro bono? That does happen, right? Well, they can accept pro bono, and by they I mean House members. They can accept pro bono representation for civil matters. But that doesn't seem to apply here. Services must be related to challenging the validity of any federal law or regulation, challenging the lawfulness of an action of a federal agency, or challenging an action of a federal official taken in an official capacity. Well, now this is talking about two cities in the state of California that canceled rallies. So that's out. So that's not it. It can't take pro bono here. What's left? Well, there's one thing that could be it, and it's called a contingency agreement. And that's basically an agreement where lawyers will only get paid if they win. And then, obviously, as the case is being litigated, there is no expenses, there's no expenditures, because they haven't paid the legal team anything. And so that's not going to get reported. Only when the case is over and they win, that's when there's an official disclosure. But even that is kind of weird, especially in this case. Getting back to Leibowitz, he said he couldn't recall any political committee ever striking a contingency agreement with a lawyer. observing that if they lose, that would mean no payments, and that would result in undisclosed provided legal services. Leibowitz said, you would expect the payment of some kind to Eastman. Someone has to pay the bills. Yeah, I mean, again, if you were working on a case for years, you would expect some sort of payoff, right? At the end. And if that's the case, you wouldn't agree to a contingency agreement. So that just does not seem plausible here. And look, getting back to who would pay it, right? Well, again, somebody has to pay it, but would it be Gaetz or Greene? We don't know. Would it be the Put America First Committee? I mean, I don't think so, because that happens to be broke. Now, that's the Joint Fundraising Committee, okay? Now, the two campaigns and that committee posted a combined $342,000 loss on the little fundraising tour that this lawsuit happens to revolve around. So they go out on tour and they lose a bunch of money. They spend a ton and don't make enough in fundraising to defray expenses. That's what we call a fail. Okay, kind of sad, a little pathetic, gigantic fail. And so I don't know. The only answer that I could come to then is into who will pay the bills, is maybe they do, have a contingency and are hoping that they win, and that they get declaratory relief and unspecified monetary damages, which is what they're asking for, and the defendants will pay for the costs of the suit, including attorney's fees. So now, look, the judge is like, you might have a point. We're going to let you bring your case. The conspiracy thing is off the table. This is ridiculous, right? But you still might have a case and them, trying to silence your viewpoint. So we're going to hear you out at least. And if somehow they do make a convincing case, and it certainly is possible, then you would have the city that would end up paying for it. But again, we don't know. There's no guarantee that they will win the suit either, even if they do, or may have a good case. And if that doesn't happen, if they end up losing this case, well, then somebody's going to get stuck with the bill. And who is it? Again, it's not going to be the committee. That doesn't have any money. So is it going to be Gaetz, that ends up having to pay it? Or is it going to be Greene that has to pay it? Or are they going to split it? I don't know. And it's not like they really like each other anymore. In fact, they're on opposite sides here, especially after they got into it for the McCarthy thing. Yeah, where Marjorie Taylor Greene was on the side of Kevin McCarthy, and Matt Gaetz actually did the motion to vacate the chair, leading to McCarthy not only getting kicked out of the speakership role, but then later on he resigned. So completely out of Congress. So yeah, there might be a bit of bad blood on that, which could get both ugly and hilarious.